Hello, this is Dr. Bechtel. This lecture covers major constitutional principles of family law. The first thing to look here, I think, to give you what I would call the 10,000-foot view so that you can understand the overall what's going on here when we start talking about constitutional law in relation to family law, is that the ever important issue that there has to be a state action, and state action is the involvement of government authorities in regulating and influencing various aspects of society, including family relations. So how the government involves itself is by making laws and policies and other interventions of the government that may have an impact on families, such as marriage laws, divorce laws, child custody, and domestic violence. So these rules and laws are going to shape the legal framework within which families operate and protect their individual rights and ensure the welfare of vulnerable members. But it can also cause some tension and conflicts when they are perceived as intrusive or when they clash with personal cultural and personal values. So that's the first thing to realize, that we're talking about state action, what that means in light of constitutional law, in light of the family law world. So there are two major constitutional laws that we look to when we're talking about government intervention, and one is due process of law and the other one is equal protection of law. Now let's take another 10,000-foot look at this phenomenon, or this issue, challenging the constitutionality. So there are some steps that we would go through. So we notice a law that affects me, and I think that I'm being discriminated against, and I'm not happy with that. I'd like it changed. So first there has to be standing. So the person bringing the suit. Basically, you're bringing a suit against the government. So you have to have standing, you have to have a direct and personal stake in the outcome, and be directly affected by the law in question. And then filing a lawsuit against the state or in the right jurisdiction. This is usually state court in light of the 14th Amendment. There's also federal court in light of the 5th Amendment. We'll get to that later. Legal arguments are made, and there's a court decision. So, what does this look like? Just like any other lawsuit. And then appeals can be made. So this is the same situation that we would face, the same scenario, if you will, overall procedural scenario, how we would go about it. It could be a lengthy process. It could have to travel from a state trial court all the way up to the United States Supreme Court, going through the various intermediate Supreme Courts along the way, and finally finding its way, because it's a federal question, into the land of the United States Supreme Court. So, due process of law, let's look to that. And I also would point out here that the way we're going to approach it is, I'm going to mention the 5th Amendment right now, and then I'm going to talk more about the 14th Amendment in the next few slides. And then we're going to circle back to the 5th Amendment. And that reality will be, well, I hope, well understood when I get to circle back. So right now, the United States Constitution in due process is requiring fundamental fairness. And that means in the judicial process, so in the process of adjudication, and in the process of making laws, there needs to be no unreasonable, arbitrary, or capricious legislation. So the courts are looking to legislation to interpret it, and that's why we have a judicial process in there. And the legislature is making the rules, making the laws, and the courts are making the laws. So all these lawmaking bodies have to exercise fundamental fairness in order for due process rights not to be violated. And we have due process is divided into procedural due process and substantive due process. Now, if you think of things like you learned in Intro to Legal Systems, where we talked about procedural versus substantive law, this is the same thing. It's just got a different context in that for procedural law, the constitutional requirement of due process is that the government provide fair procedures such as adequate notice and an opportunity to be heard. And that's when the government seeks to deprive someone of these constitutional rights to life, liberty, or property. So in procedural due process, we're looking to how the government that is intervening as a result of a particular law, or a particular government action, and they have to treat issues of notice and hearing very carefully. It focuses on those methods or the steps that the government uses to implement the content. And the content is the substantive law, the substantive due process. And that's the requirement that the government avoid arbitrary, capricious actions that deprive someone, same thing, life, liberty, or property, regardless of how fair the procedures were. The legislation, the content of that legislation, what the government is doing, for example, terminating parental rights, requires that the legislation be reasonable, have a legitimate purpose, and use reasonable means to effect reasonable end. So that's the broad stroke of United States Constitution due process. And it's broken down it's about fundamental fairness requirement in making law and intervening on, in this case, the family unit. And there's procedural and substantive, with procedural being the how, the movement of the methods and the movement and the steps used by the government, and the substantive, which is the content, what the law says, what it's saying. Does it, all orange trees shall be orange. That would be the content of the statute. That's what we're looking at. So in constitutional law, under the procedural due process, the government has to provide fair procedures if it's going to deprive someone of life, liberty, or property. But you know that from the last slide. The added principle here on procedural due process is that depending on the seriousness of the deprivation, that may raise the level of procedural rights required, or obligations, if you will, of the government required because of that seriousness. My example that I thought of this morning is driver license laws, or taking away my driver license is not nearly as serious as taking away someone's welfare benefits, or taking away someone's that's just the seriousness of the deprivation, and or even the law itself may line up so that the class of people are deprived or whatever. But without going too far, just know that that level of procedural right that people are entitled to under the due process clause are telling us that the seriousness raises the bar for the government to do more for notice and hearing. All right, so the other overall context that we need to know about constitutional law is that we have fundamental rights and we have non-fundamental rights. And there are three categories of fundamental rights, and those are the ones specifically guaranteed by the U.S. Constitution, or implicit in the concept of ordered liberty, or deeply rooted in the nation's history and tradition. So let's just give an example of C. Back in the earlier, if you watched the introductory lecture, I talked about women and marriage and the ownership of property back in the day. So that was deeply rooted in the nation's history and tradition. So that's what we're getting at there. Just an example of what that is. A non-fundamental right would be a right that doesn't fall into A, B, or C, which are fundamental rights. So those categories, A, B, C, don't apply, but a non-fundamental right could be advanced from government intervention in the form of legislation or lawmaking of any kind that doesn't fall into that. Pause while my dog gets bad and I yell at him. I apologize if my little critters bark a little bit. One is still very young, only a year old. So that concludes that slide. So we've finished talking about, then we have the substantive due process. This is the content, remember? And so when judges are looking at the content, they use strict scrutiny in fundamental right cases in looking at the content of the law, which is looking at legislation or previous cases, where, say, you're coming up the ladder to an appeals court, and each time they are looking at fundamental rights, they must use the strict scrutiny test. And what they look to with the strict scrutiny test is that the restrictions placed on these people, whoever they are, must be narrowly tailored to serve a compelling state interest. It's clear from the legislation or the precedent that the fundamental right asserted in a constitutional challenge against the government has to be narrowly tailored to serve a compelling state interest. But a non-fundamental right would follow the rational basis, which is restrictions must be reasonably related to a legitimate state interest or purpose. So I'll return back to my earlier example of the driver license versus the termination of parental rights. Termination of parental rights would be strict scrutiny. The driver license being taken away would be, or the laws related to a driver's license, or the interventions of the government regarding my driver license would be tested using the rational basis test. So again, we're talking about equal protection. I sometimes call it EPL. And this is where I need to ensure that you understand, right now we're talking about the 14th Amendment, which prohibits states from denying any person within its jurisdiction the equal protection of the laws. And these 5 bullet points here, a little bit premature, but this is just giving you the overall fundamental rights judged by strict scrutiny, suspect class judged by strict scrutiny, quasi-suspect class judged by intermediate scrutiny, and another class was judged by rational basis. And we'll look at each one of those individually here in the next few slides. So the coverage, though, for EPL has been expanded to invalidate all laws and procedures that unreasonably discriminate. And know that equal protection of laws, its purpose is to protect stigmatized groups from discrimination. And my dog is barking, and I apologize for that. He needs to grow up, but he will. So, equal protection, EPL. This is the constitutional requirement that the government treats one group or class the same way as it treats another group or class in like circumstances. So the context has to be the same, the circumstances have to be the same. And the focus when we're dealing with EPL is the unequal treatment of groups or classes that result from a law. Classification, as we were talking about earlier, there's a classification of the group or class. Classification used in constitutional law refers to a group or class that the government treats differently from another group, meaning the government has discriminated for or against a certain group or class. The constitutional question, when we're challenging laws that affect equal protection, so there's unequal treatment of a group, the challenge is whether a classification violates EPL. So is that law, does it include a classification that treats one group differently from another in like circumstances, and does it violate the equal protection of laws? That's the challenge. All right, so equal protection of laws, and again, we're focusing on state laws here. And we still have the same rights in the federal law system. don't get too confused, but we need to circle back on EPL in Fifth Amendment, in light of the Fifth Amendment, a little differently. But in the situation where we're dealing with fundamental rights, remember they're categorized three ways: A, B, and C. Guaranteed, implicit, or deeply rooted. If it falls into any one of those three categories of fundamental rights, then a suspect class that's designated in a legislation, or maybe it's precedent, the outcome of a previous case, which is adjudication. The class is based on race, national origin, or alienage. So suspect class, that's what it means. And so that's a class based on race, national origin, or alienage. And those fundamental rights are there, but this is just an extra definition you need to understand what suspect class means. So examples of legislation. This is a legislation because it's a statute example in family law. It allows same race couples to marry, but not mixed race couples. So there's a statute out there, and then if that were challenged under the Equal Protection Clause of the 14th Amendment, the court would need to use the strict scrutiny test, and that is that the suspect class designation in the legislation or other form of law is necessary to serve a compelling state interest. So a compelling state interest means that the interest is of the highest order and that a clear justification of the necessities or necessities of national or community life. Now, equal protection of the laws classification, 14th Amendment again, we have a quasi-suspect class categorization. Now, dealing with fundamental rights or non-fundamental rights, a class based on gender or a child's legitimacy is where quasi-suspect class is defined. The class is gender-based or legitimacy-based of a person. Examples of these types of suspect class regulations or laws, and these are statutes, so they're legislation. It would be a statute allowing ex-wives to receive alimony but not ex-husbands, or a statute that allows children of married couples to inherit from their parents but not the illegitimate children of their parents. So we had laws like that, the court, and they were being challenged under equal protection of laws of the Constitution. In this case, the 14th Amendment we're talking about. The test used is intermediate scrutiny. So it's a test in the tier. The first test, as we talked about, was strict scrutiny. This one, basically, when we're dealing with challenges to laws based on class, on gender, or legitimacy of a person, the classification must be substantially related to serve an important state interest or purpose. And that means that the interest is significant. Now, lastly, there's the quasi-suspect class under the 14th Amendment. So it doesn't involve a fundamental right. And when it doesn't involve a fundamental right, a suspect class or a quasi-suspect class, we still use the 14th Amendment and to challenge that law. This is an example of one, an ordinance that restricts the city of use of a city-owned pool to adults with children, and so that would be the test of legitimate state interest. There needs to be, we need to challenge it, and the government needs to defend it, and its defense would be that any government objective that the state has the authority to pursue, such as to provide for public safety. So just looking at that simple example, I don't know what legitimate state interest there is in that, but again, remembering this is to protect people from discrimination. So now we circle back, as I promised we would, to the Fifth Amendment. EPL is a federal government action is covered by the Fifth Amendment, but the Due Process Clause of the Fifth Amendment while it covers EPL, it does cover EPL, but it does not have an EPL clause, an equal protection clause. But the U.S. Supreme Court has interpreted the due process clause as including equal protection. So that's why I sectioned everything out, and if you're in my class right now in spring 2005, the book has broken it down like this too, circled back to Amendment 5, the Fifth Amendment, so I'm trying to keep it the same way. So the United States versus Windsor is an example of how the Supreme Court of the United States, it held that it was unconstitutional for the federal government to define marriage as a union of man and woman for purposes of federal benefits and duties, even in a state that allowed same-sex marriage under state law. So when we have these conflicts between state and federal law, and this conflict is not really the problem here, the conflict is that the federal government had the Defense of Marriage Act, as Congress had enacted the Defense of Marriage Act, saying that marriage would be between a union of marriage is between a man and a woman. But states had their same-sex marriage laws coming about, and so there was this conflict, but the challenge to it wasn't the conflict of laws, but rather the equal protection under the federal government. And just understanding that applies to the federal government laws of the federal government, like this one of Congress that said man and woman for you.
Some of us are familiar, at least in broad terms, with the landmark decisions of the U.S. Supreme Court. Decisions like Brown v. Board of Education, Roe v. Wade, and others, which have fundamentally shaped the American political landscape. But how are those decisions actually made? Who bears the burden of proof, and how much proof is required to make a decision? This question is operationalized through the lens of the levels of scrutiny. In the simplest terms, levels of scrutiny refer to the standards that the courts use to determine the constitutionality of a government act, especially when individual rights or equal protection claims are at stake. These standards dictate the rigor with which the courts will examine the governmental interest against the rights or interests of the individuals affected. The level of scrutiny applied by the courts essentially centers on the question of what motivated the government's action. What's the purpose of the legislation or act? Based on the answer to this question, the courts will place the government's purpose into one of three categories. Governmental actions that do not involve any suspect classification or fundamental rights, that is, most governmental actions, are subject to a rational basis review. Governmental actions that impact gender are generally subject to an intermediate level of scrutiny. And governmental actions that impact a suspect classification or fundamental right, that is, laws that classify individuals based on race or ethnicity, or which affect fundamental rights like voting, privacy, First Amendment rights, and so on, are subject to strict scrutiny. The rational basis review is the most deferential standard towards the government. A law or action may be upheld if it's rationally related to a legitimate government interest. In such cases, the individual challenging law has the burden of proof to show that there's no conceivable legitimate government interest or rational relation to that interest. To defend the law, the government must only show that a law is reasonable and not arbitrary. The rational basis review is used to evaluate most laws and governmental actions, especially when they don't involve a suspect classification or burden a fundamental right. At the intermediate scrutiny level, a proposed law or action must be shown to be substantially related to an important government interest. Here, the government has the burden of proof to show that it has more than just a legitimate interest. It must demonstrate that the interest is important and that the law is a suitable means to achieve that end. The law must be more narrowly tailored than under the rational basis review, but doesn't have to involve the least restrictive means. Intermediate scrutiny is most often applied to cases involving discrimination based on gender. Finally, strict scrutiny is the most rigorous and least deferential to the government. Here, the government has the burden of proof to demonstrate that the law or action is narrowly tailored to achieve a compelling government interest and that it employs the least restrictive means to achieve that interest. This standard is applied when the law targets a suspect classification like race, national origin, or sometimes religion, or burdens a fundamental right like the freedom of speech or the right to marry. In summary, the levels of scrutiny come into consideration when the courts are evaluating the constitutionality of laws or governmental actions that limit or infringe on individual rights, or that classify individuals in a way that might lead to discrimination. The more fundamental right, or the more suspect the classification, the higher the level of scrutiny applied, and the harder it is for the government to justify the law or action in question. But that's it for now. Please leave any questions you have in the comments section below, and thanks for watching. Most of us are familiar, at least in broad terms.
Okay, so I hope that, I really like that video. It does a nice breakdown of what I just said in a different way, so it's nice to hear things in more than one way. And now we'll look at an example. We're going to use same-sex relationships as applied to the United States Constitution. Now is an example of same-sex marriages. And this is an older video.
This is Sheldon Amott at Toronto Penn College of Law, and I want to provide a bit of an introduction to equal protection analysis and what are called levels of scrutiny. When government classifies on the basis of different considerations, basis of activities, basis of business, basis of groups that people belong to, we are in an equal protection world. And when we are in an equal protection world, the question arises is whether the particular classification the government uses is constitutional under the Equal Protection Clause. There are three, perhaps four, categories of equal protection analysis or levels of scrutiny. The first is what we would call strict scrutiny, which applies to so-called suspect classifications. Racial classifications, classifications based on ethnic origin, and the like. When we talk about strict scrutiny, we are talking about placing a very heavy burden of justification on government, so that governments have to show that their classification is based upon a compelling governmental interest, and even if it is, the second inquiry is whether it is narrowly tailored to achieve the governmental purpose. That's strict scrutiny, the highest level of scrutiny in the equal protection world. The second level is something below that, called, not surprisingly, intermediate level scrutiny, and that applies to sex-based classifications, whether directed at women or at men. Here, there is still a fairly heavy burden of justification on government, but it's less than that under strict scrutiny. So that here the government has to show that there is an important governmental interest at stake, and that the means used, the classification, is substantially related to that important governmental interest. The third category of equal protection analysis is what's called rational basis review. Whenever there is no good reason to view a classification with any kind of suspicion, as for example with strict scrutiny or with intermediate level scrutiny, we use rational basis review. Very deferential indeed, typically applies in situations involving business matters, economic regulation, and the like. There is probably a fourth category of equal protection scrutiny analysis, and that is actual purpose review, where if we were to use rational basis review, we could perhaps conclude that the governmental classification was rational on this, that, or the other ground. But when we inquire into what is really going on, what the actual purpose is, if it turns out that the actual purpose is to single out for disadvantageous treatment a particular group of people because of who they are, that would violate the Equal Protection Clause under actual purpose review. Good examples, Romer v. Evans, handed down by the Supreme Court years ago, which involved discrimination against homosexuals just because of who they were. And similarly, the case that is currently one of the two same-sex marriage cases currently before the Supreme Court, the Perry case, in which the Ninth Circuit used actual purpose review based upon Romer. Interestingly enough, and this is my final point, with respect to the second of the two cases, before the Supreme Court, the Windsor case, the Second Circuit used intermediate level scrutiny for sexual orientation discrimination. And that is something that the Supreme Court has not yet done, and we'll see whether it does it in either or both of these cases.
So that was a fairly dated video of the same-sex relationships, and I chose it for the examples that it helps to build upon the previous video with things in a nice, tidy way. But the examples are super important, and I share with you that that these are the outcomes. That was 2011 when he made that video. These decisions hadn't been handed down yet. And as pointed out, they're looking to more to autonomy and actually in the last slide page, the court looks more to the focus of personal dignity and autonomy. So that's a advancement, I guess, or a change that we need to recognize, that personal dignity and autonomy are important principles in the area of challenges to legislation based on gender or class. And those were successful cases for the people. There was Edith Windsor. She fought this is a headline from her death, but this is a good article if you want to read a little bit more about what happened there. And then we had the Supreme Court in the other case, the Windsor case and the Perry case. The Perry case were two women who wanted to marry. They challenged the California law, and they won. And so now it's no longer an issue at the present time. All right, so there's something also to always keep in mind. We have two constitutions. I'm in Florida. We're in Florida. We have a state constitution. Every state has a constitution, and all those state constitutions have to comply with the federal constitutional law. State constitutions, it sets a threshold. And when we use the state constitution, it may give more benefit, increase the rights to an individual than the federal constitution does. So it's just important to recognize that there are two. And when we get to, I have another lecture I'm preparing on how we, I'm preparing on areas of law, the sources of law, and I'll get a little bit more into that when I get to that stage. So that concludes this one on the U.S. constitutional law and family law. Thank you very much.